Welcome to WeLearn, Virtual Learning Network. This is session number 12, Judiciary. Topics which we are going to cover in this session are evolution and development of judiciary in India, the Supreme Court, jurisdiction of the Supreme Court, the High Court, subordinate court, judicial review and judicial reforms. Coming towards the first topic, that is evolution and development of judiciary in India. The development of judiciary in general can be traced to the growth of modern nation state. During the ancient time, administration of justice was not considered a function of state, as it was based on religious law or dharma. The king had no true legislative power, the power to make ordinance on his own initiative and pleasure. With the advent of British rule in India, judicial system on the basis of Anglo-Saxon jurisprudence was introduced in India. The royal character of Charles II of the year 1661 gave the governor, the council, the power to adjudicate both civil and criminal cases according to the law of England. It was with the Regulating Act of 1773 that the first Supreme Court came to be established in India, located at Calcutta. The Supreme Court consisted of Chief Justice and 3 judges appointed by the Crown, and it was made a King's Court rather than a Company's Court. The Federal Court of India was established in Delhi by the Act of 1935. This was to act as an intermediate appellate between the High Courts and the Privy Council in regard to matters involving the interpretation of the Indian Constitution. Next topic is the Supreme Court. The entire judiciary has been divided into 3 tiers. At the top there is a Supreme Court, below it is the High Court, and the lowest rank is occupied by the Sessions Court. The Constitution says that the law declared by the Supreme Court shall be binding on all small courts within the territory of India. Below the Supreme Court are the High Courts located in the states. Next are the composition and appointments in Supreme Court. The Supreme Court consists of the Chief Justice of India. When the Supreme Court was inaugurated, it had only 8 judges. Its strength has risen to 25 judges. The President of India, who is the appointing authority, makes these appointments on the advice of Prime Minister and the Council of Ministers. To eliminate politics in the appointment of judges, high minimum qualifications have been prescribed. For appointment of the Supreme Court, a person should be a citizen of India, a judge of High Court for at least 5 years, or should have been an advocate of High Court for at least 10 years, or a distinguished jurist in the opinion of the President of India. Next is tenure. Once appointed, a judge holds office until he attains 65 years. A judge of Supreme Court may resign his office or may be removed in case of misbehavior or incapacity. The motion of impeachment against a judge was tabled in Parliament for the first in 1991, when an audit report revealed several irregularities committed by the judge during his tenure as the Chief Justice of the Punjab and Haryana High Court. A three-man judicial committee was set up with the serving and a retired Supreme Court judge and the Chief Justice of Bombay High Court. Next comes the salaries, a very important element that determines the independence of judges is the remuneration received by them. The salary and allowance of the judges are fixed high in order to secure their independence, efficiency and impartiality. The Constitution also provided that the salaries of the judges cannot be changed to their disadvantage except in times of financial emergency. Next are the immunities. To shield judges from political controversies, the Constitution grants them immunity from criticism against decisions and actions made in their official capacity. The court is empowered to initiate contempt proceedings against those who impute motives to the judges in the discharge of their official duties. Next topic is jurisdiction of the Supreme Court. Article 141 declares that the law laid down by the Supreme Court shall be binding on all courts within the territory of India. The different categories into which the jurisdiction of the Supreme Court is divided as follows. These are original jurisdiction, appellate jurisdiction, advisory jurisdiction and review jurisdiction. Coming towards the original jurisdiction, the Supreme Court has original jurisdiction firstly as a federal court. In a federal system like that in India, both the union and the state government derive their powers from and are limited by the same constitution. Under Article 131, the Supreme Court is given exclusive jurisdiction in a dispute between the union and a state or between one state and another, or between a group of states and others. The Supreme Court also has non-exclusive original jurisdiction as the protector of fundamental rights. Article 32 of the Constitution gives citizens the right to move the Supreme Court directly for the enforcement of any of the fundamental rights enumerated in Part 3 of the Constitution. The court can decide the legality of detention and release the person if detention is found to be illegal. Prohibition is the right to prevent a court or tribunal from doing something in excess of its authority. By the right of certainty, the court may strike off an order passed by any official of the government, local body or a statutory body. Quo warrant is the right issued to the person who authorized occupies a public office to step down from that office. Next is the appellate jurisdiction. The Supreme Court is the highest court of appellate in all courts in the territories of India. Article 132 provides for an appeal to the Supreme Court from any judgment or final orders of the court in civil, criminal or other proceedings of a high court if it involves a substantial question of law as to the Interpretation of the Constitution. Article 133 of the Constitution provides that an appeal in the civil cases lies to the Supreme Court from any judge, order, or civil proceeding of the High Court. Article 134 provides the Supreme Court with appellate jurisdiction in criminal matter from any judge, final order, or sentence of the High Court. The Supreme Court has a special appellate jurisdiction. Next is the advisory jurisdiction. The Supreme Court is vested with the power to render advisory opinion on any question of the fact or law that may be referred to it by the President. The advisory role of Supreme Court is different from ordinary adjudication in three senses. There is no litigation between two parties. The advisory opinion of the court is not binding on the government. It is not executable as a judgment of the court. Next is the review jurisdiction. The Supreme Court has the power to review any judgment pronounced or order made by it. This means that the Supreme Court may review its own judgment order. The American Supreme Court deals primarily with cases arising out of the federal relationship or those relating to the constitutional validity of law and threats. The advisory jurisdiction of the Indian Supreme Court also is something absent from the pure view of the American Supreme Court. Next is the High Court. The Constitution provides for a High Court at the apex of the state judiciary. Chapter 4 of Part 4 of the Constitution of India contains provision regarding the organization and functions of the High Court. By the provision of Article 125, which says there shall be a High Court for each state. Every state in India has a High Court, and these courts have a constitutional status. The Parliament has the power to establish a common High Court for two or more states. In case of union territories, the Parliament may by law extend the jurisdiction of the High Court to or exclude the jurisdiction of High Court from any union territory or create a High Court for a union territory. Next are the composition of the High Court. Unlike the Supreme Court, there is no minimum number of judges for the High Court. The President from time to time will fix the number of judges in each High Court. The Chief Justice of the High Court is appointed by the President of India in consultation with the Chief Justice of India and the Governor of the state, which in actual terms means the real executive of the state. A judge of a High Court normally holds office until he attains the age of 62 years. He can vacate the seat by resigning, by being appointed a judge of the Supreme Court, or by being transferred to any other High Court by the President. A judge can be removed by the President on grounds of misbehavior or incapacity in the same manner in which a judge of the Supreme Court is removed. Next is jurisdiction. The original jurisdiction of the High Court includes enforcement of fundamental rights, settlement of disputes relating to the election of union and state legislature, and jurisdiction over revenue matters. Its appellate jurisdiction extends to both civil and criminal matters. In civil matters, the High Court is either a first appeal a first appeal or the second appeal court. In criminal matters, appeal from decisions of the sessions judge or an additional session judge where sentence of imprisonment exceeds 7 years and other specified cases other than petty crimes continue the appellant jurisdiction of a high court. The Constituent vests the high courts with 4 additional powers: the power to issue rights or order for the enforcement of the fundamental rights, the power of superintendence over all other courts and tribunals except those dealing with the armed forces, the power to transfer cases to itself from subordinate courts concerning the interpretation of the Constitution, the power to appoint officers and servants of the High Court. Next is the subordinate courts. Under the High Court, there is a hierarchy of courts which are referred to in the Indian Constitution as subordinate courts. The state is divided into districts and each district has a district court which has an appellate jurisdiction in the district. Under the district court, there are the lower courts such as additional district court or sub-court, etc. At the bottom of hierarchy of subordinate court are the panchayat courts. The principal function of district court is to hear appeals from the subordinate courts. The Constitution ensures independence of subordinate judiciary. Appointment to the district court are made by the governor in consultation with High Court. A person to be eligible for appointment should be either an advocate or a pleader of 7 years standing or an officer in the service of union or the states. Next is judicial review. Judicial review has a more technical significance in public law, particularly in countries having a written constitution founded on the concept of limited government. Judicial review in this case means that court of law have the power of testing the validity of legislative as well as other governmental actions. The reference to the provision of the Constitution. In England, there is no written constitution. The Supreme Court's power of judicial review extends to constitutional amendments as well as to other actions of the legislature, the executive and the other government agencies. Under Article 368, constitutional amendments could be made by the Parliament. In the early year, the court held that a constitutional amendment is not law within the meaning of Article 13 and hence would not be held void if it violated any fundamental rights. All former amendments that violated the fundamental rights to property would found to be unconstitutional. When a law remains in force for a long time, it establishes itself and is observed by the society. If all past amendments are declared invalid, the number of transactions that took place in pursuance of those amendments become unsettled. The Supreme Court clarified that no future transaction or amendments contrary to fundamental rights shall be valid. The technique of treating old transaction valid and future one invalid is called prospective overruling. The court also held that Article 368 with amendments does not contain the power to amend the Constitution, but also prescribe the procedure to amend. In 1970, when the Supreme Court struck down some of Mrs. Indira Gandhi's populist measures such as the abolition of the privy purses of the former prince and nationalization of bank, the Prime Minister set about to assert the supremacy of the Parliament. In 1972, the Parliament passed the 25th Constitutional Amendment Act, which allowed the legislature to encroach on fundamental rights if it was said to be done pursuant to give effect to the directive principles of state policy. One of the limits of judicial review has been the principle of locus stans. This means that only a person aggrieved by an administrative action or by an unjust provision of law shall have the right to move to the court for redressal. In 1988, the Supreme Court delineated the matters to be entertained in PIL. Next, the most striking criticism against administration of judge is the large number of pending cases in the delay in the dispensation of judge. In the early 90s, there were more than 2 crore cases pending in different courts. The availability of multiple remedies at different rungs of the judicial ladder also enable honest and recalcitrant suitors to abuse the judicial system. Now these are the questions which are based on this session. These are: explain judicial reforms, and question number 2 is explain subordinate courts. That's all for this session. Thank you. Happy learning. Be learning.